May it please your lordships,
Yes.
may I beg to mention item 16:16. I've received instructions only yesterday. So may I pray that some time may be granted so as to file my affidavit.
Okay. So I've just put up a note. We'll pass the orders as and when the matter reaches.
My lord, if it may be fixed on 22nd July, Wednesday,
Why?
22nd July. Because next week we will be having vacation.
Okay, okay.
22nd, my lord.
Right. We'll pass the orders as and when the matter reaches.
Please, your lordships. Lordships, I beg to mention item 25. Here I've received the case records. I've prayed that some time may be granted to file the affidavit, lordship.
Habeas corpus.
Yes, your lordship.
How much time?
2 weeks, your lordship.
We'll fix a date.
Lordship. Because I have to send it to PEC for the
That's okay.
detaining
But
authority.
this is
Yes.
a detention matter, so
Yes,
we
yes.
have to fix a date.
Lordship.
Mr.
M. Longkumar.
M. Longkumar, learned government advocate, appearing for the state, submits that he has received the instructions and therefore prays for 2 weeks' time to file the counter affidavit. In view of above. Release the matter again on 15th July
Your lord-
2026.
Lordship.
The state respondents and the other respondents may file their counter affidavit. To file their counter affidavit in the meantime. All right.
Lordship, I have a similar prayer for item 26 and 27. The habeas corpus, your lordship.
Okay, similar order. 26, 27 also. Okay.
Lordships, I beg to mention item 30 on behalf of additional AG and Team Song. We pray that some time may be granted to file an affidavit in opposition for this IA.
IA is by you only, state.
Yes,
Objections filed by the sole respondent already. What more to be filed?
That is what I was instructed by the additional AG, your lordship.
on the last occasion, this additional AG sought time to file additional affidavit, but it was supposed to be filed before the next date, and because it was not forthcoming, we filed our objection. As per the court's direction, we were supposed to file our objection by 22.
You have filed an objection?
Yes, lordship.
What is the additional affidavit?
This is condonation application.
Yes.
That was in item 43. Item 30, I don't know. I don't think there's any such kind of order. Item 43, additional affidavit to be filed on the delay. But 30, there is nothing like that. Only record says objection filed already.
Your lordship.
But you want to file additional affidavit or what?
Your lordship,
But you're not the counsel, we don't know.
yes.
Let the matter be called, we'll see.
Your
As
lordship.
the matter comes, we
Yes,
will
lordship.
pass the order.
Oblige, your lordship.
Yes.
Yeah, please, your lordships. Lordships, I beg to mention item 37, lordship. Lordship, if this matter can come up after vacation law, I have taken the consent of the parties, opposite parties.
What is the matter?
Lordship 302 IPC.
302.
Lordship.
Okay. Mr.
Vijamomi,
V. Zimomi, learned PP,
lordship.
Nagaland submits that as he has some personal difficulties to conduct the case today, he prays that the matter be adjourned and be listed again after the ensuing summer vacation. The prayer is not opposed to by the learned counsel for the appellant. In view of above, list again after the summer vacation on a date to be fixed by the registry.
Oblige.
Repeat your lordships. Lordships, I beg to mention hearing item number 35 and 36. Lord, here my senior Mr. Ijimomi, he is out of station.
Okay.
So if this
Adjournment slip has been served
Yes, my lord. Yes, my lord.
and other side has agreed to.
Yes, my lord. I've informed.
When do you want it?
After the vacation, my lord.
Miss Lucino, learned counsel for the petition, for the appellant submits that she's led by Mr. A. Zimomi, learned counsel in the matter, and since he has some personal difficulties to conduct the case today, she prays that the matter be adjourned and listed again after the ensuing summer vacation. Stop. She also submits that she has circulated an adjournment slip which has been agreed to by the opposite party. Ms. V. Shukre, learned additional AG, Nagaland, submits that she has no objection to the prayer. In view of above, matter stands adjourned. We will list it again after the ensuing summer vacation on a date to be fixed by the registry.
Similar prayer for item numbers 39 and 40 also, my lord. Here also I have informed I have taken the consent from the opposite party.
But here, Mr. Gupta is there, isn't it?
Yes, my lord.
Only for one. Or
No, my lord, he's appearing for, yes, my lord, he's appearing for the enforcement director. Yes, my lord, ED.
ED.
Yes, my lord.
1 and 2 is ED.
Yes, my lord.
Number 3 is the tribunal.
Tribunal, my lord.
Is that
It's a
former
former respondent, my lord.
But notice
Former
you have to go or not?
My lord, in fact, my lord, the other day, this court was of the view that we shouldn't have made the tribunal a party. So it's just a pro forma. So, my lord.
Supposing you file MSCT appeal,
Yes, my lord.
do you make the presiding official party?
My lord.
Same thing.
Yes, my lord. Yes,
Anyway, you pass the same order as 35, 36, okay? Same as
Yes,
35,
yes, ma'am.
36. Parties also same. Luciano is there.
obliged, my lord.
Yes.
May it please your lordship.
Yes.
Lordship, kindly allow me to mention item number 15. Lordship, here I have filed in IA. However, the same is not listed along with the appeal. Kindly allow me to move unlisted, Lordship, along with the appeal.
I hear for what?
IA for suspension of bail order, extension of bail order, Lordship. I was granted temporary bail, Lordship, by this honorable court to undergo
Up till when? Up till when?
till
Temporary
29 of this month,
29 of this month.
Lordship.
Okay, so when did you file the IA?
Monday, day before yesterday, Lordship.
That's a mention memo.
Lordship,
Okay. I get listed then. 15, isn't it?
Lordship. Much obliged.
Yes.
Lordship, may I be permitted to mention item number 38 from the hearing list? I'm for the private respondent and Lordship, this is a consent prayer if this matter can be listed after the vacations.
Writ appeal.
Yes.
Yes, sir.
I'm for the appellate.
No objection.
No objection.
What is your good name, please?
Adezukire.
On the prayer of Mr. Alozukira, learned counsel appearing for respondent number 5.
Yes, madam.
They're not objected to by the other side. Matter stands adjourned. We will list it again after the ensuing summer vacation on a date to be fixed by the registry.
I'm obliged for it.
My pleasure, Lordship. Lordship, I beg to mention item number 12 on behalf of Tipagong. Lordship, may kindly list this matter after vacation. I've taken the consent of the petitioner.
State appeal.
Lordship.
We don't want scale pay to be paid to the petitioner. Okay. On the prayer of on the prayer made on behalf of Mr. E. Tibapong, learned government advocate, appearing for the state appellants and not opposed to by the other side. Matter stands adjourned to be listed again after the ensuing summer vacation on a date to be fixed by the registry. Okay.
I pledge.
With these lordships, I beg to mention hearing item number 33. Senior counsel for respondent number 4 to 11 is indisposed.
Item number 33.
Yes, your lordship.
Who's disposed, indisposed?
Senior counsel R. Iralu.
Item 33.
Yes, lordship.
Oh, Mr. Iralu is for the respondent.
Respondent number 4 to 11.
Have you taken consent?
Yes, I've taken the consent.
Mr. R. Iralu, learned senior counsel, appearing for the respondent numbers 2 and 3.
4 to 11.
I'm sorry, 4 to 11.
Yes, Your
He
Lordship.
said to be indisposed, and a prayer for adjournment has been sought on his behalf by Miss
Menoshino.
Menoshino, learned counsel. Stop the said prayer is not opposed to by the learned counsels, appearing for the other parties. In view of above, matter stands adjourned.
Lordship, if the matter can be fixed on a particular date, Lordship, because this matter has been dragging on for 2 years, Lordship.
When do you want it then? Consensus? Prayer? 15 July?
15th of July, Lordship. No further adjournment, please, Lordship, because this is a matter of senior promotions, Lordship. So many promotions have been held up, Lordship, because of the pendency of the.
You are the writ petitioner.
I was the writ petitioner.
Writ petitioner.
Yes.
Yes. Because
15
down,
15
down, the,
maybe.
down the lane,
Is there any interim order?
No, Lordship.
no, Lordship.
No.
Mr. Mozui, the writ petition was dismissed. What difficulty do you have? Writ petition was dismissed.
Lordship,
Yes,
yes.
There's nothing.
It's gonna be fixed on 15, Lordship.
Okay, list on 15th of July 2026.
Lordship.
All right.
Obliged, Lordship.
Yes.
Please, Your Lordships, I beg to mention item 22 and 23, Your Lordship. Your Lordship, may this matter be listed after 2 weeks after the vacation, Your Lordship.
Why?
Your Lordship, I have personal difficulty today, Your Lordship. I've taken the consent of the petitioners.
Who's the petitioner? A. Sophie. M. Solo.
My lord,
Any objection?
my lord, if she have difficulties, then no objection to this.
Is A. Almi, learned PP.
No. Your
Learned
Lordship,
government advocate
Yes, Your Lordship.
submits that, appearing for the state submits that she has some difficulty in conducting the case today. And therefore, prays that the matter be posted again after the ensuing summer vacation. Counter affidavit filed?
Yes, Your Lordship, I find.
She submits that the counter affidavit has also been filed by the state respondents. In view of above, list the matter on 15th of July, 2026.
Like Your Lordship. Your Lordship,
Same order in item 23 also.
yes, Your Lordship, this is our analogous. And Your Lordship, I also beg to mention item 45 from the supplementary list, Your Lordship. This may also be listed after vacation, Your Lordship.
45.
45.
Who's for the other side?
Lordship, I'm for the petitioner. Lordship, this pertains to suspension from service.
Correct. Your writ petition was rejected.
Lordship,
You filed this appeal. If you want some time, what to do?
Lordship, in that case, a date may be fixed, Lordship.
15 July?
Lordship,
Okay. Miss so-and-so, learned government advocate, appearing for the state respondent, submits that she has some difficulty to conduct the case today. And therefore prays that the matter be adjourned to be listed again after the summer vacation. The learned counsel for the appellant submits that if such difficulties expressed by the government advocate, he will not object to the same, but prays that the matter be listed immediately on the list again on 15th of July 2026. You record Miss IME.
Inahuli, Your Lordship.
I'm sorry, Inahuli. Just Inahuli or
Yes, Your Lordship, just Inahuli.
All right. 15th of July.
Much obliged, Your Lordship.
obliged, Lord.
Yes, you may call. Any motion?
For motion, item number 41.
Yes, Miss Koza.
Your Lordships. Lordship, through this instant PI, Lordship, the petitioner is approaching this court seeking intervention, Lordship, on with a earnest prayer to monitor the progress of the road construction, Lordship, because in package 2 portion, particularly in package 2 portion of Kohima Jasami Road, Lordship. Because the respondent number 7, who is a EPC contractor here, has caused inordinate delay, yes, Lordship. And interestingly, twice the contract was also terminated, Lordship. But they are continuing with the work. We have no objection. Petitioner has no objection with the whoever the contract is. But since the people are really suffering, Lordship, 4 districts, people from 4 districts, Kohima, Pak, Kifire, Meluri are dependent. It's a lifeline, Lordship, for this, especially 3 districts, Lordship. And this road is also equally important because it serves as an interstate road. And not only that, Lordship, it is also an international road connecting Myanmar, Lordship. Now, what has happened is that, Lordship, even in the project monitoring groups meeting, this serious deliberation has been conducted over and over again, Lordship, regarding the delay. Now, what has happened? NHITCL has on 19/8/2024, Lordship, given a notice for termination of contract, citing series of reasons, Lordship. Now, they said even after 220 days after signing the contract, the contractor has physical progress of only 0.39%.
Who's the contractor? Respondent number?
7, Lordship. Yes.
Yes, who's appearing for the state?
Lordship, I'm appearing for the state.
You need to get some instructions.
Lordship.
This is a PIL, not an adversarial litigation.
Lordship, yes.
So what is happening in the road construction, we have to update us by filing an affidavit. When can you file the affidavit? And who will be the person to file the affidavit? From the government side?
Lordship, it would be
Ms. Koza, who will
Yes,
be
Lordship.
who's the person concerned in the state?
Lordship, in the state, it's the Deputy Commissioner Respondent number 5, 6.
4
and-
and 5. 4, 5, and 6. 4, 5, and 6.
Deputy Commissioner of Thek and Kohima.
Lordship, yes, because it's connecting, Lordship.
Okay.
And also Chief Engineer Respondent number 6, National Highway, Lordship.
But what has the Deputy Commissioner to do? It's
Lordship-
normally done by the Public Works Department.
Yes, Lordship. They are he's a convener, Lordship. Overall, they oversee the project, convener of project monitoring group, Lordship. In fact, he's recommended. He's also written to the Commission in Nagaland to terminate the contract on 24th of November 2000 last year, Lordship.
When, Acha, one thing,
Lordship, yes.
by which order was the work allotted to the contractor? Do you have that?
Lordship, my apology, Lordship. I could not produce it today, Lordship. We have filed an RTI in this regard, Lordship.
The NIT is also otherwise there, isn't it?
Lordship, yes, it is there, Lordship.
Annexure
It is
3.
Lordship. Lordship, page 34, it's the retendered for the balance work, Lordship.
Balance work.
Balance work. Initially, they were doing, and then the deadline was 30th June 2022. They failed to meet the deadline. The contract was cancelled, terminated, sorry. Then balance work was retendered. Here again, respondent number 7 participated along with 2 firms, Lordship. It's in page number 36, Lordship. Then work order was not, I could not produce it today, Lordship, but I will be producing during the next processing once we get the required documents, Lordship.
No, we have to get the facts right.
Yes, Lordship.
Initial tender was issued when? Initial tender? You're talking about retender now.
Lordship, yes. So, Lordship, as far as information given to me was, Lordship, para 2 of my petition, I've mentioned that
Retender,
Sorry, Lord.
how much work? How much work was left?
it was for Lordship retender
Balance work for 2-lane.
from 30.474 kilometer to 53.22.
What happened to the earlier tender?
Earlier tender it was cancelled, Lordship,
Why?
because they could not meet the deadline. They could not complete
Contractor.
the work, yes, Lordship.
So this retender was done.
Retender was
Then
done.
who has been selected?
Then same, Lordship, respondent number 7. Same contractor was selected.
Okay, same contractor was selected.
Yes, Lordship.
And he has completed only 0.39% of the work.
That was as on 19th of August 2024, Lordship. Lordship, in fact, if you kindly go to the letter, termination notice letter dated 19/08/2024, page 43.
19 August 24 is 2 years back, you see.
Yes, Lordship.
How can you say it's now 0.39?
No, that was during that time, yes.
As of now.
As of now, Lordship, as per the DPDP meeting, Lordship, it is showing as
Now, this balance work has to be completed within 24 months.
Lordship, within 24 months, Lordship, yes. Now, what has happened? They have given assurance that they were completed by 10th of June 2025. That was not done. That's why the Deputy Commissioner has recommended the termination on 24th November 2025. Now, Lordship, if you turn to page number 70, Lordship, this is a meeting minutes of the DPDP meeting, District Planning and Development Board, held on 14 May 2026, wherein it is seen that the contractors were given the opportunity to give a PowerPoint presentation, Lordship. Now here, if you go to agenda point 1, Lordship, package 2, this is, yes, this is, yes, page 70, Lordship. Now, as on 14 May 2026, Lordship, the physical progress is showing only 41.28%, and financial progress is showing only 40.31.
So what is the timeline otherwise, as per the NIT?
So as per the NIT, it was supposed to be completed, Lordship, by 4th of January 2026, Lordship. But here in the DPDP meeting, the NHIDCL.
Where do you say that? From where do you say that? 4th of January 2026?
Lordship, in this DPDP meeting, respondent number 2 NHIDS has informed the House that timeline has been extended till September 2026, Lordship.
Where is that?
It's in page number 70, Lordship. Here, if you go to agenda 1, Lordship, the subpar, it is not numbered.
That is the extension.
Yes, extension was
But you said
granted.
that the timeline was to complete by January or February of 2026. From where are you
Yes,
saying?
if you go to page number 66, in the project monitoring group's meeting minutes, Lordship. Para 67, Lordship. Para 2, Lordship.
For January?
Yes, Lordship.
The NIT otherwise says that 24 months.
24.
Lordship, yes.
This is in the year 2023.
23.
And when was the work allotted to the contractor? When did he start the work? These facts you have to tell us.
Yes, Lordship.
Overall, it appears that there's some delay in the work, but at least you have to give us the facts.
Lordship, yes.
At least by bullet points also. This is what has happened.
Lordship, yes.
Number 1, this is the tender. Number 2, this is the selection. This is non-completion, termination of the contract, again, re-tender.
Lordship.
work given, meeting held 1, 2, 3, and today's status is dispatch, like that.
Lordship, yes.
Let me-
My due apology, Lordship. We tried our best, Lordship. In fact, we even requested for inspection of documents under Right to Information Act, but that was not allowed, Lordship, by the HIDCL. So
Okay,
Lordship, we are awaiting response. But since there's urgency, Lordship, because now rainy season has started, Lordship. Even in fact, Lordship, few days back, till yesterday, I think, Lordship, students union, the Apex Students Union body was also protesting, Lordship, because it's really affecting the people.
Who are the petitioners here?
Petitioner is a tribal apex body of the Chakasang tribe, Lordship. Chakasang Public Organization, Lordship.
What do you say, sister? Ms. Koza,
Lordship, yes.
you do one thing, you produce the NIT
Lordship.
and you just give us the list of dates, what
Lordship,
has
yes.
happened and how it has happened. Prima facie, it appears that there's some delay. We're
Lordship, yes.
in order to, get a response from the other side. So we need to at least recite some facts.
Lordship, if
So-
Lordship, if a direction may be kindly given to NHIDCL to allow us to obtain the documents, Lordship, because as I stated, Lordship, we have filed RTI for inspection of documents, Lordship, seeking all this information. Till date, no positive information response, Lordship. Lordship, yes, all documents are with them, Lordship, in fact,
With whom?
with NHIDCL, Lordship, because they are implementing agency, Lordship.
So you can take recourse to the provision of the RTI.
Okay, Lordship, not by
Uh,
first direction, Lordship. When there is a specific act,
you apply for it, they don't give you within a specific period, you have the right to have an
Yeah.
appeal.
the provision is there for appeal also, Lordship. So
That's why.
that is
So-
altogether a different issue.
Lordship, again, it will,
As Lordship, has-
30 days is the time frame, Lordship. Then again, they will delay for another 30 days, Lordship.
I know, but we can't help it, you see.
Logic.
We find the facts to be a bit minimal, you see. At least you have to enlighten us, what is what.
I understand, Lordship. I completely understand, Lordship.
We posted on 15 May, 15
Logic.
July again, and
Logic.
you do something about
Lordship.
production of the thing in the meantime. Please write by filing this PIL.
Lordship,
The-
in the meantime, if notice can be kindly be issued, Lordship, we will also simultaneously.
That is for the purpose of issuing of notice.
Lordship, yes.
See, we don't want to issue just notice just like that just to find out what has happened. You have to establish your case. Prima facie, you have to satisfy us. Okay, we'll write like this, on the prayer of Ms. Nita Koza, learned counsel for the petitioner. Matter stands adjourned to be listed again on 15th of July 2026. In the meantime, the petitioner may file an additional affidavit incorporating additional materials to support the contention made in the PIL. Okay?
Lordship, yes.
Life.
Promotion, item number 42.
Yes, this is also your appeal.
Yes, Lordship. Now, the appellant is before this court, Lordship. He is aggrieved by the impugned judgment dated 30th of April 2026, Lordship.
Appellant is the convict.
Yes, he is convicted, Lordship, on the charge of Section 376, clause 1, subclause 2L, Lordship, and Section 370, subclause 1, clause 1, subclause 2, human trafficking, Lordship, and also Section 293 of IPC, showing obscene material, Lordship. Now, the petitioner, in fact, appellant has a ground, Lordship. He states that he has been maliciously prosecuted and wrongfully convicted, Lordship. In fact, it's a very strong case, Lordship, in this case. No, the court has convicted him relying on the testimony of the victim, Lordship, the prosecutrix, and which carries major inconsistencies, Lordship. And it does not meet the principle laid down by the Honorable Supreme Court, Lordship, as a sterling witness, Lordship. Now, on the charge of Section 293 IPC, Lordship, showing obscene material. The obscene material was not even examined, Lordship. It's not even exhibited in the court. And without examining the material, the trial court has erred, Lordship, in reaching a conclusion. Also, on the charge of human trafficking, Lordship, it's very interesting. What has happened is, it is the complainant, Lordship, and her family who are harboring a foreigner, Lordship, illegal without passport, visa, and they are exploiting her without giving her any payment. Now, what has happened? She sought refuge going to the house of the petition appellant here. The appellant has served his entire career, Lordship, in the ministry. Dedicated his entire life in the ministry, Lordship. He also went to US and he was serving in the ministry as a pastoral work for the last 25 years, Lordship. Now what has happened, as he come back, thinking that he's in his old age, he will come back, do something for the society. In fact, complainant and her husband are their close family, friend only, Lordship. Now what has happened, prosecutrix sought appellant's help. She walked all the way, Lordship, during the construction of Four-Line Road, Lordship, on 8 July 2019, Lordship. She walked from Kohima to Zubza, looking for the appellant. No, the appellant, after hearing the story that she was exploited, she was abused, he decided to extend help. And as requested, on her request, he was sent back to Mon. She was sent back to Mon on her request, Lordship. Now, what has happened? In the police station, Lordship, in the police station on 17 July 2019, a conference call was made connecting the prosecutrix from Mon police station, where entire police personnel along with the
Ms. Koza,
yes, Lordship.
tell us, you are convicted under what sections of law?
Lordship, section 376, clause 1, subclause 2, and subclause L, Lordship. Then section 370, clause 1, subclause 2, Lordship. And section 293 IPC, Lordship. These are all IPC, Lordship.
363 also?
Yeah, no. 363 was dropped, Lordship, for kidnapping.
Okay.
And POCSO, section 4 POCSO was also dropped, post-trial, Lordship.
It was dropped?
Yes, Lordship. Because prosecution fabricated a false document, Lordship, birth certificate issued by Church of Myanmar.
So the conviction is mainly under 376, 1, 2, and L.
Yes.
293, 370, 1 and
Lordship, yes.
POCSO is dropped.
POCSO is gone.
360 also dropped.
Lordship, yes.
What is 293 and 370?
293 is showing obscene material, Lordship.
Okay, and 370?
370 is human trafficking, Lordship.
Human trafficking.
Lordship, yes.
Okay. We'll examine the appeal.
Lordship, yes.
And notice need not go to the informant if POCSO is dropped.
Lordship, yeah, we have made her a party also.
You made a party.
Yes,
Then
yes.
it's okay, we'll issue notice.
Okay, Lordship.
Right, Ms. Niti Koza, Learned Counsel for the appellant, who submits that being agreed with the judgment and order dated 30/4/2026, passed by the Special Court POCSO, Kohima, Nagaland, in sessions bracket special close bracket GR number 66 of 2019, by which the appellant was convicted under section 376 bracket 1 separate bracket 2 and separate bracket capital L, as well as under section 293 and 370 bracket 1 bracket 2 IPC, has filed the instant appeal by invoking section 415 bracket 2 of the BNSS of the learned counsel submits that the prosecution miserably failed to prove the case against the appellant, and conviction was mainly based on the statement of the prosecutrix, despite the prosecutrix being short of a sterling witness. To stop, she therefore submits that the impugned conviction and sentence passed against the appellant should be set aside. Now, I forgot to mention the sentence. Where is that sentence?
A sentence, Lordship, it's a Lordship, if you go to page 3, Lordship, the judgment is
Page 3.
from page number 91, Lordship.
This one. I think she's made a chart here. Just read the beginning part. So and so.
Lordship, the relevant portion is
It's okay, let's move to this. No, before that, beginning part. Beginning. After that, you add separately, full stop. For the conviction under 376, section 376, bracket 1, bracket 2, bracket capital L IPC, the appellant has been sentenced to rigorous imprisonment for 10 years and to pay fine of rupees 10,000 with a default clause. Stop. For conviction under section 370, bracket 2, bracket 1, bracket 2, IPC, he has been sentenced to undergo rigorous imprisonment for 7 years and to pay fine of rupees 5,000 with a default clause. And for conviction under section 293 IPC, the appellant has been sentenced to undergo simple imprisonment for one year and to pay fine of rupees 1,000 with a default clause. This is by the same order or a separate order?
same order, Lordship.
Okay. Then last part, in view of above, issue notice, let the appeal be admitted. Is there any delay? What is the date of sentence?
No delay, Lordship.
No delay.
Yes.
Okay. In view of above, let the appeal be admitted. Call for the TCR. Issue notice to the respondents, returnable by 3 weeks. Miss Livika, learned additional PP,
PPL.
learned PP, accept notice on behalf of the respondent number 1
Yes, Lord.
and petitioner to appellant to take steps for service of notice upon the respondent number 2 by speed post
Lordship.
within 3 working days. Extra copy of the memo of appeal be furnished to the learned public prosecutor within 2 days. Place the matter again on receipt of the TCR.
Obliged, Your Lordship.
For orders, item number 13.
Paper book ready?
Yes, Lordship.
You have received paper book.
Yes, Lordship.
This is an appeal from jail.
Yes,
You're
Lordship.
the amicus.
Yes, Lordship.
Amicus. And who's the PP?
Lordship, Lordship.
You have received paper book
Yes, Your Lordship.
and you are for the
Lordship for the respondent number 2.
Miss Kiki.
Lordship.
The parties are represented by the respective councils and they submit that they have received the paper book and therefore the matter may be fixed for hearing. In view of above, registry to list the matter for hearing as per its own time.
Grateful, Lordship.
For orders, item number 14. Here also, Lordship, the paperwork is complete. However, respondent number, the complainant is, we have served notice.
Also,
Yeah, yes, Lordship. This one is,
Where is the notice?
no, Lordship, this is a C 3023 case.
Or 302?
Yes, Lordship.
Who's the respondent number 2? Complainant.
Yes, Lordship.
No one appears.
Yes, Lordship.
Do we require to appoint somebody? Oh, you have a list of legal aid counsel? He's right. Parties are represented by the respective counsels except for respondent number 2. Despite service of notice. Respondent number 2 is the complainant. And having regard to the issue involved, we deem it proper to appoint so and so as a legal aid counsel to represent the respondent number 2. Since paper book is ready and already supplied to the learned counsel for the appellant as well as the state, registry shall also furnish a copy of the paper book to the legal aid counsel, Joshua, Mr. Joshua Siki, learned counsel. Then last part, the registry shall also furnish a copy of the paper book to Mr. Joshua Siki within a week. This is the matter for hearing as per its own text.
Obliged. For orders, item number 15.
This is item 15.
Lordship.
I has come. You have received a copy of the IA.
Yes, I have received it.
Oh, yes, what is your ground?
Lordship, if I may take your Lordship to Annex E, page 53. Lordship, this is the last medical report. As per this medical report, I was to review after 1 month of medication.
Now, what is your ailment?
Sorry, sir.
Your ailment,
To undergo laparoscopic surgery, Lordship,
for what?
to remove gallbladder stone.
Gallbladder stone.
Lordship. However, like
When was it? When were you diagnosed? And whether operation has been done already or not?
Lordship,
Am I audible? So whether operation is done or not?
So operation is done.
not yet, Lordship.
Why?
Lordship, I have manifold health complication. As such, as per the
Like,
if I may take your Lordship to
everybody has complication.
Lordship, if I may take your Lordship to page
Hypertension,
9,
BP and all.
para 9,
Huh?
para 9 of my IA, Lordship.
Para 9.
Lordship, my health complications are hepatitis C, high blood pressure, and bleeding prostatic hyperplasma. Lordship, as such, the medical expert have
Hepatitis C,
Lordship.
BP. BP is common, you can take medicine.
Lordship, I have, as per the last report, that is the latest report, page 57, page 55. I was to undergo 1 week medication, Lordship. If I may take your Lordship to right side corner, that's medication. The last line, right side corner. It can be seen as BP 183/100, which is beyond normal. And as per the doctor advice, I could not undergo the surgery with this pressure. As such, I was given 1 week of medication. Thereafter, I am to report to.
When?
I'm to admit on hospital on 16/7/2026, and the surgery to be done
Where's that? Where's that?
on 17.
From where you seen that?
Para 8, Lordship.
Huh? From?
Para 8, Lordship.
Para 8.
Yes. And for the same, the doctors have given.
You are showing us page 55, then again you're taking us to para 8.
Lordship, my apologies, Lordship.
Para 8. Para 8 will be page 4.
Page 4, Lordship. Lordship, there has been a clerical error which should have been 17 instead of 7, Lordship. My apologies, Lordship.
Sixteen, you'll get yourself admitted. 17 will be the surgery.
Lordship.
As per which document?
As per page 57, Lordship, if I may take your Lordship to page 57. This is to whom it may concern, given by the concerned doctor, Lordship. May I read to you, Lordship? Mr. Y. Yabang Longkumar, 48 male, HIN 7967111, has been diagnosed with HTN, DM, HCV, and cholestasis and placed for surgery. Due to uncontrolled HTN surgery has been postponed on 12/6/2026 and reviewed on 19/6/2026 and placed for surgery on 7/7/2026 and advised hospital admission on 6/7/2026.
What is the allegation you're convicted under what provision?
Section 6 of POCSO Act, Lordship.
POCSO Act.
Lordship.
And your age is only 48 years.
No, Lordship. Lordship, I am more than that. However, as per my Ayushman card, it has been wrongly entered as 48. Now, in order to avail that Ayushman benefit, I have to go by this when it comes to medical.
What is your real age?
Real age is 56, Lordship.
You should book him again. For
This is only as per my Ayushman card, Lordship, which has been wrongly entered.
yes, what do you say, Ms. Devika?
Your Lordship, actually on the last 3 occasions, like they were seeking time, extending the bail, on the ground that he has to undergo medication. But since there's a recommendation by the doctor, Your Lordship, to undergo surgery. So yes, I feel that in the interest of justice.
How much time are you seeking otherwise?
Till when? Till when are you seeking?
Lordship, I am no medical expert as such. I am not in a view to give, but 2 months may be proper, in my opinion.
Your operation is supposed to be what? What is the
on 70.
procedure? What is the procedure?
It's a laparoscopy.
Laparoscopic surgery, Lordship.
Do you know what is laparoscopy?
Lordship, I'm not well aware. Lordship.
Then why are you appearing before for the applicant? You don't know what is what.
Lordship, laparoscopic surgery to my basic.
We are not doctors, but at least you should the basics.
Lordship, to remove my gallbladder stone, Lordship.
Correct, but laparoscopy is a procedure wherein you don't cut open people.
No, Lordship.
They just drill a small
Keyhole,
hole,
Lordship.
keyhole,
Lordship.
and people walk out the same day.
Lordship.
Same day they walk out.
Lordship.
So how do you say that I require 2 months?
Lordship, I might also need to get recovered, Lordship.
See, you will recover definitely. You'll take good rest in jail.
Yes, sir.
Lordship.
Free food, everything is there. Medicine's advanced now. You see, laparoscopy. Now, people go in the morning, get it done, and come back in the afternoon.
Lordship.
Of course, you have to take care after that. Definitely, you can't be do your activities normally like other days, but at least you take care. But you're not supposed to be admitted like that.
Lordship.
So, how much time was granted to you on the last occasion?
45 days, Lordship.
Before that?
Before that,
It was 45
60 days.
Yeah, 60 days and 45.
First, it was 60.
First 30,
First 30.
followed by 60, Lordship. And thereafter 45 days.
30, 60, then 45.
45.
Lordship.
Okay.
I have been on bail 130 days by now, Lordship.
130.
Yes, Lordship.
I think the
Altogether.
calculation is 139. But today is only, see, we're in June,
Lordship.
June 24th. If the thing is supposed to happen on 7th of July. So how much time should be required?
Maybe 30 days.
But 30 days, Your Lordship.
30 days will, until when?
To have
I think it'll take him up till end of July Today's 24th, that means 30 days means 24th or 25th of July,
Lordship,
correct?
Lordship.
That happens to be Friday or Saturday like that.
Friday. 24 July will be
Ah.
Friday.
I think a month's time is good enough.
Lordship, as it please your Lordship.
Heard, Mr.
James Newmine.
Okay. Heard, Mr.
James Newmine.
James, in my learned counsel for the applicant who submits that by filing this application, the applicant seeks the extension of bail. Where was the last bail order granted to you?
14/5/2026.
A copy of the order, please.
Annexed D, Lordship, page
Okay.
48.
Extension of the bail granted to the applicant, provide order dated 14/5/2026, passed in IA criminal number 22 of 2026. Stop. The learned counsel submits that the applicant has been diagnosed with where is the ailment?
If I may assist your Lordship, 8/7, page 4.
What is the name of your ailment?
What is it called? Litiasis. Litiasis.
Has been diagnosed with spelling, okay? CHOLETI. TI what? PITHIASIS. Page 53, okay? You'll find the spelling there, page 53. And for which he is required to undergo a surgery by way of laparoscopy. Stop. Although the applicant was planned to have surgery on which date?
On 6/5/2026.
On 6/5/2026. But due to his health condition, he could not be operated upon. Stop. According to the doctor, he has been advised to be under medication and to report for surgery and plan for surgery on 7/7/2026. Stop. The applicant has been advised to get himself admitted in the hospital on 6/7/2026. Stop. The learned counsel submits that considering the medical advice and the planned surgery and the condition of the applicant at this stage, his health condition is not conducive to be in jail, and therefore the bail granted to him earlier on 14/5/2026 may be extended. Next para, Ms. Livika, learned public prosecutor, submits that the applicant was granted bail initially for 30 days on medical grounds, and thereafter the same was extended for 60 days. 60 days. Followed by another extension of 45 days. Stop. She, however, submits that in view of the medical advice given by the doctor concerned, court may consider the same and pass appropriate orders as it deems fit and proper. Upon considering the submissions made and upon perusal of the application filed by the applicant, we are of the view that the applicant should be granted further extension of bail in view of the surgery planned on 7/7/2026. Stop. Accordingly, the bail granted by the order dated 14/5/2026 in IA criminal number 22 of 2026 stands extended for another 30 days from today. Was there any terms and condition?
No, Lord.
Plus, the last extended period is expiring on 29th, Your Lordship. So I think.
From 29?
Yes.
1 month from 29?
29.
Yeah, it's expiring on 29th. So
The
if
45 days
will
expired.
be made effective today, or it's up to the court. Your Lordship.
Wow.
I'm just apprising the court.
29, isn't it?
It's expiring on 29th.
29. So make it 29 with effect from 29th of June 2026. The date on which the extended bail order is to expire. Stop. It is made clear that upon expiry of a period of 1 month from 29/6/2026, the applicant shall surrender before the jail authorities. With the above observation and direction, the application stands disposed of. Then what about the main appeal?
The main appeal, Lordship, I have received the
Paper book.
paper book, Lordship.
In the main appeal, you write, any respondent is here,
Lordship, the complainant.
complainant.
Yes, as per this honorable court direction,
Anyone appearing?
no one appeared so far. I have, as per this honorable court instruction, I have given a scanned copy to the PP, which is to be routed to the concerned PS and thereafter by concerned PS to the complainant.
What is
Yes, Your
the,
Lordship. It is served, Your Lordship.
huh?
It is served, Your Lordship.
Served.
Yeah,
Served.
it is served.
How do you say that?
Your Lordship, the IO informed Your Lordship.
No, how verbally?
Yes, Your Lordship.
You should get it by way of written. It should be by way of writing.
Oh, Your Lordship, then I will, on the next day, I will.
In the main appeal, right, the parties are represented by the respective counsels except for the respondent number 2. So Ms. Livika, learned public prosecutor, submits that the copy of the scanned copy of the appeal memo has been served upon the respondent number 2. Stop. It is, however, seen that the submission of the learned PP is as per the oral instructions received by her. Stop. Therefore, the learned PP shall get written instructions about service of notice upon respondent number 2 by the next date. List again on 15th of July. Need the orders called.
Much.
Much.
For orders, item number 16. Mr. Shankam had appeared
Yes,
for
ma'am.
adjournment.
Yes, ma'am.
Now, we have seen that the notice has not been served upon the respondent numbers 7, 8, and 9. Anyone appearing?
Lordship,
Yes,
I'm appearing on behalf of the petitioner, Your Lordship.
okay. What is your good name?
P. Suren, Lordship.
Mr. P. Suren, learned counsel, appears for the petitioner to RVC. Stop. Mr. L.T. Sankam, learned additional advocate general, appears for the state respondents and prays that he may be granted some time to file the counter affidavit as he has received instructions. Stop. He also prays that the matter be listed on 22nd of July.
Yes, ma'am.
2026. Next para. Office note dated 17/6/2026 indicates that return service report from the respondent number 7, 8 and 9 is still awaited. Next para in view of above. That the matter will sit again on 22/7/2026 as paid for by the learned additional AG. Stop in the meantime, registry shall track the postal consignment of the notice sent to respondent number 7, 8 and 9 and put up a note.
Much.
For orders, item number 17.
May I please, your lordships. Lordships, this IA is praying for condonation of delay of 78 days, your lordship. It is under Prevention of Money Laundering Act, lordship. Now, lordship, when this matter was listed on the last occasion, objection was advanced by the counsel for the respondent number 1 and 2, saying that in the CI system, your lordship,
Just a minute, delay for?
47 days.
Okay, 47 days.
Now, this delay is counted from the date of the judgment, your lordship. That is 29/10/2025. We filed on 11/2, lordship.
Date of judgment up to?
29/10/2025. It was that is the date of judgment. So
Just a minute, take your time, see. Now, this is an application under 42 of the Money Laundering Act.
yes, your lordship.
Now, what is the period of limitation?
60, your lordship.
60 days.
Yes.
Now, when was the judgment passed?
29/10/25, your lordship.
29/10/25.
Yes, your lordship.
And
So
when did you file the appeal?
11/2/2026.
11/2/2026.
Yes, your lordship. So from the date of judgment, this appeal ought to have been filed on 26/12/25, your lordship.
Okay.
So there's a delay of 47 days. Now, your lordship, on the last occasion, you received the counsel for the respondent number 1 and 2 raised an objection stating that in the CIS, your lordship, the filing date is given as 9/3/2026. It is March, which exceeds your lordship. Now, this is a mistake on the part of the system, your lordship. So we wrote a letter to the registry, your lordship. Now the reply is placed before your lordship in the filing, it seems, your lordship. It's dated 19/June/2026. Where they have stated that, is it there, your lordship? Later dated 19/June/2026.
It is there. I've seen it.
Yes, your
Now,
lordship.
who's appearing for the other side?
Mr. YP Gupta appeared, your lordship.
Where is he? Last time you objected.
Yes, your lordship.
Now today is not there. So will condone. They filed it on a particular date, okay? On 11th. But then the matter was attended to later. So that's why they say that that should not be on our account. It should be on account of the registry. I think there's no problem. The district could not attend to such and that benefit should not go to benefit should go to the applicant. But at least not to the. He was, I mean, some adjournment was sought in some other cases also. Isn't it? Was it today? Today only somebody has adjourned his matters. Since he is not here, what to do? Okay, please write. Ms. Esther, learned counsel, appears for the applicant and submits that by filing this application, the applicant seeks condonation of 47 days delay in filing the appeal. Stop. She further submits that Mr. Y. Gupta, learned counsel, appearing for the respondents on the earlier
1 and 2.
respondent numbers 1 and 2 on the earlier court date had raised certain objection stating that the delay is not 47 days since according to the CIS, the date of filing is
registered as 9/3/26.
is registered as 9/3/2026. Stop. In this connection, we have perused the office note dated 17/6/2026, wherein it has been stated that the case was, although the case was filed on 11/2/2026, registration of the same in the CIS was done only on 9/3/2026 after certain rectifications which were detected had been done. Stop. Having regard to the office note, to the explanation made in the office note, we are of the view that as the application had been filed on 11/2/2026, the delay in registration of the application should not be the reason for what do we say? Should not be reason for should not be a reason for not to accept the delay of 47 days as projected by the applicant. Stop. In other words, the delay to be condoned will have to be considered as 47 days. Stop. However, as Mr. Gupta, why Gupta is it? Why Gupta? YP Gupta. YP Gupta, Learned Counsel for the respondent numbers 1 and 2 is not present today. The matter stands adjourned to be listed again when? 15th of July 2026. It is also observed herein that if the respondents do not file any objection, in the meantime, the matter will be taken up for consideration on the basis of materials available on the court.
Much obliged.
For orders, item number 18.
You're not filing any affidavit.
Why not?
You're for one, respondent number 1. You're for the Union of India.
Yes, my lord. I filed.
You have filed.
Yes.
Respondent number,
1.
but it's not available in the file. Only 2, 3, and 4 are filed. And 2, 3, and 4 has filed two affidavits. Why? One is not enough.
No, Your Lordship, the first affidavit was signed by the Special Secretary. So, Your Lordship, the court had directed that it should be filed by the Commissioner of Police, by the detaining authority.
Oh, that's why. Detaining authority. So the second one is filed by the detaining authority.
My lord, I have filed on 7 and 6 of 2026.
On
17/6 of 2026, my lord.
17/6.
Yes, my lord.
Then why is it not connected to the report? It's there, it's available to the. So, master. Yes. Rejected where? No, then if it's rejected, you should keep a note here so that we also know what is what. You have received a copy?
Yes, Your Lordship.
You also have received a copy. But I think there's some technical difficulty in the registry, for which it has not been.
Otherwise, Your Lordship, the affidavit of the detaining authority will be relevant. Otherwise, Union doesn't have much then.
What did you say in your affidavit?
My lord, through papers they have sent me so that accordingly I filed them. But,
What did you say? Did you say?
no, actually, they have said that they have received the representative submitted by detainee and they have acted upon the representation of detainee. Accordingly, from the truth, the department is acted up, looking after the representative of the detainee. And there is no grounds and measure cause so that it is registering. That's what. And that registration order is communicated to the jail superintendent and as well as the detainee madam.
So what is to be done?
Can proceed for hearing, Your Lordship, because I'm already serving on extension, the preventive detention.
Since when?
On 9, Your Lordship. 19.
19th of what?
January.
Since 19th of January, you are
Yes, Your
detained.
Lordship. Yes, and extended for further 3 months.
You're detained under what provision?
NSA, Your Lordship.
NSA.
Yes.
Not at CGC, you have an extra copy of your affidavit.
Yes, my lord.
Give us your extra copy. Okay, you may start.
Your Lordship, the other two petitions connected in the following items. The other two items, they're all connected.
They're all connected.
Yes, yes, yes. Over the same offense, different persons.
Different persons.
Yes, Your Lordship. Over the same offense. Lordship, I was arrested on 5/12/2025. And an order for detention was passed on 30 January 2026, which is at page 21 of the writ petition. Approval.
You were arrested on?
5/12/2025.
Then?
And approval was given on 30 January 2026 for preventive detention.
Approval by?
Approval by the Chief Secretary.
Government.
Yes, Your Lordship.
Before that, what is the detention order?
Yes, that is at page 23, Your Lordship.
What is the date?
19 January 2026.
Is the detention order?
Yes, Your Lordship.
By the commissioner?
Yes, Your Lordship. The grounds of detention is at page 27. The relevant portion will be the third paragraph, Your Lordship. Now, therefore, in pursuance of Section 5 of the said Act, the undersigned hereby informs you that the said detention order has been met against you on the following grounds. A. Security of the state of Nagaland. B. Maintenance of public order. The grounds of arrest, Your Lordship, is at page 62.
Page
62.
62.
Yes.
Grounds of arrest.
Yes, Your Lordship. Lordship, there will be a document which is important, page 55. Checklist for arrest. Page 55. The first condition, Your Lordship, whether arrest is necessary to prevent the accused from committing any further offense. Nothing has been marked, Your Lordship. And page 56, Your Lordship, again. Page 56, point number 6, reasons necessitating the arrest. 1. To prevent the accused person from committing any further crime. I don't fall under that category also, Your Lordship. Because this is a checklist, it has to be complied with in terms of the judgment and order passed by the Supreme Court, Your Lordship. That is Arnish Kumar versus State of Bihar. Yes, yes, which is at page 55, Your Lordship, top. As per the direction of the Honorable Court in the matter of Arnish Kumar versus State of Bihar.
No, why do you say that 6 is not applicable to you?
Your Lordship, which one?
Page 56.
They should have stated, Your Lordship, if I were to be arrested and detained, it is to prevent me from committing further offenses, Your Lordship. So I'll be coming that on subjective satisfaction, Your Lordship.
So this column is blank, isn't it?
Yes.
The entire column is blank.
Yes.
Not only one.
A complete procedural lapses, Your Lordship. On my arrest.
Then?
My grounds of contention is, Your Lordship, I was arrested on an alleged offense of abduction, Your Lordship. Abduction. And then, for abduction, there are normal laws which can try this offense. So there was no need of putting me under the preventive detention when it is triable by a normal law. And I was already in custody, Your Lordship. Yes, I filed a bail application, but it was not decided, Your Lordship. It was pending. And it is not a case of national security or a public order, Your Lordship, as stated in the grounds of detention. The complainant, Your Lordship, whom allegedly I have abducted, Your Lordship, he was a truck peddler. And I belong to one of the faction groups in the state. So we nabbed him, Your Lordship.
You belong to?
The faction groups, and it's I am, Your Lordship. But the complainant who has lodged a complaint against me, against which I was arrested, he was a truck peddler. We had information. And we had seized some drugs also from him. And then a case was filed against us, and then we were arrested. But let that be subject to the trial court. I will not contest on that as of now. Lordship, page 36 again. Proposal for detention, there was one ground, particular ground, Your Lordship,
Page
36. Grounds on which the 4 arrested persons are proposed to be detained under NSA. The ground number 4 will be relevant. One of the arrested accused, namely so-and-so, steering committee so-and-so, is a habitual offender of serious crime. It has been established that he was earlier arrested on so-and-so along with 5 other accused on grounds of extortion registered with police station so-and-so. He was one of the co-accused, Your Lordship. And for an offense committed by some other person, why should I be put under preventive detention? So this entire grounds of detention was done in a mechanical process, Your Lordship. Which cannot sustain the test of law. Otherwise, it will be a violation as direct violation of my rights under Article 21.
What is page 36? This is a
Page 32, the first page, proposal for detention. It's a continuation of the page 32.
written to the commissioner by the deputy commissioner.
Yes, Lordship.
4 arrested persons, you
Yes.
said, no?
Mm.
You are one of them.
Yes, Your Lordship.
And 3 of them are before this court,
Yes, 3 of them.
18, 19, 20.
Yes.
And this person named at paragraph number 4 is not,
He is also there, Your Lordship.
no, he has not applied. He has not filed the habeas corpus.
He has filed, Your Lordship, in the next petition.
Which one? Item 19.
13, yes. WP petition criminal 13.
Filed by whom?
His wife, Your Lordship.
His wife.
Yes.
This is also by wife.
Yes, Your Lordship. So the grounds of detention was in a mechanical process, Your Lordship, without application of mine. And even in the case of the person who is a habitual offender, preventive detention is a law which is not a punishment for a past offense, Your Lordship, just to prevent the future offenses. One cannot be detained for a past offenses. Otherwise, it will amount to a punishment without a proper trial. And on going through the affidavit filed by the respondents, Your Lordship, one of the grounds they have taken in the affidavit is a bail application was filed by the petitioners, and there was likelihood that we will be released on bail. That is not the ground of my detention, which was served to me. Because in a preventive detention, the grounds of arrest has to be detailedly served to me in a language that I understand, and that I will be released likely on a bail. That was not the grounds of my detention. It's just an improvisation in the affidavit.
Show us the order of detention.
Page 21, Your Lordship.
21.
Oh, 26, yes, Your Lordship.
26. Then grounds of detention 27.
Yes.
But in the schedule, it is stated that you are presently under judicial custody and has moved for bail.
Yes, Your Lordship.
21.
Filing of bail will not be an obstacle for me to, will not be an obstacle. But the respondent has to show that on material that there was every likelihood for me to get a bail for the subjective satisfaction. And there is no materials to show when in the affidavit that I was likely to be released on bail. And I was just filing the bail application. If that is a reason for the detaining authority to put me under preventive detention, then indirectly that is a bar, putting a bar or an embargo for me to file a bail application, Your Lordship. It restricts me from exercising my legal rights. Only the detaining authority can answer this, but I don't know what convinced these authorities that I will be released on bail.
143 BNS has punishment for a term only up to 7 years.
Yes,
So
Lordship.
there was every likelihood if you had applied for bail, it's not as if it's 10 years or life imprisonment.
Then the gravity of offense, Your Lordship. The gravity of the offense. Whether it was
not just the gravity, because detention has nothing to do with the gravity of the offense in the criminal trial. This is to prevent you from doing
Yes, Your Lordship.
prejudicial activities. So the prejudicial activities is stated extortion.
But nothing was available to them, to the respondent, to the detaining authority that I will be committing this offense in the future also.
You are associated with the group,
Yes, Your Lordship. 4
of you in all.
Yes.
Four of them, one of you has been described to be an habitual offender also.
Yes, Your Lordship.
So that speaks, you're in a company of persons who are habitual offenders.
Lordship, but habitual offender means a balance has to be struck between the security and the liberty, Your Lordship. Preventive detention cannot be used as a punishment for a past offense.
It's not for past offense. They say that is to prevent you from indulging, to prevent him from indulging in activities prejudicial to the security of the state and to maintenance of public order. Is the ground they've taken. You have filed any representation?
Yes, Your Lordship. It was rejected.
Was rejected.
Yes, Your Lordship.
What about the advisory board?
The role of advisory board? It was on the recommendation only that I was put under preventive detention.
Advisory board. I think that comes later on.
Advisory board.
Advisory board.
Decision disposed by the advisory board.
No. We have not made a representation on that. I have met to the Home Ministry. Which is at page 97, Your Lordship.
97.
Yes, Your Lordship.
You have made to the ministry.
Yeah. This is the content of the wireless message transmitted from the Home Ministry.
It's normally rejected, isn't it?
Yes.
Normally rejected.
Yes.
And the state also normally rejects it.
Yes.
Now, what does the advisory board say? Anything on that point, Ms. Ayami?
Lordship, the case records are here.
No, you go through it and tell us. Otherwise, we'll have to search everything ourselves.
Your Lordship, as per the advisory report, after having gone through all the records, they have made the observation that there is sufficient ground for the preventive detention of the detainee, Your Lordship.
Advisory board,
Yes, Your Lordship.
they have made a,
Yes, Your Lordship.
they
The
have,
report is
they
also
have,
here.
they have given a report.
Yes, Your Lordship. The
You flagged the
observation.
report, you flagged the report.
Yes, I flagged it, Your Lordship.
ICGC, this is very fast. You need that different landing. You have prepared this list of dates.
Yes, Your Lordship. Advisory.
Some dates. These are important.
Annexure N, Your Lordship. Advisory report.
Oh, annexure
N. I flagged it there.
N. Okay. Yes. But what is this? This is a typed copy. Like N.
That's the report of the advisory committee, Your Lordship.
There's
The
no,
original will also be there.
there's no signature. That's why I'm asking you. This is a typed copy. Advisory report. Submission clause. Yes.
What else?
Your Lordship, that's all, Your Lordship.
Oh.
The affidavit says that I was likely to be released on bail. That is why I was detained. And that has to be stated in my grounds of detention. Otherwise, it will violate my constitutional rights.
So your contention in your writ petition is that you are arrested for abduction.
Yes, Your Lordship.
And in fact, for abduction, there's a normal procedure.
Normal is there, yes.
And bail also was pending, and
Yes.
definitely you'll apply for bail.
Yes.
If you're arrested, you apply for bail. There's no satisfaction or apprehension on the part of the detaining authority that you would be released on bail.
Yes.
And therefore, the detention is passed in a mechanical manner.
Yes, Lordship.
And detention is basically not for a punishment for the past deeds.
Yes.
It's basically to prevent you from doing, like future illegal activities
Yes.
only. And therefore, mentioning about the past conduct cannot be the ground for your detention.
Yes, Lordship.
These
And
are the things which
yes,
you have said.
most importantly, that there was likelihood of me to be released on bail.
That is not mentioned.
That is not part of the grounds of my detention. That has to be stated.
And do you have any authority in support of your submission in that
No,
regard? Then you are confidently saying that that has to be there. No. It has to be supported by something.
The law is clear, Your Lordship.
There are so many
And the checklist of my arrest.
Miss IME also will come and say opposite. She'll say law is very clear. We can detain. Then what to do?
The checklist of my arrest also did not mention that but the grounds of my arrest was to prevent me from committing future offenses.
This is a checklist, that's all.
But a mandatory provision which has to be complied with in terms of the apex court judgment.
checklist is to do with the criminal case.
Then we'll hear the other side. If you have anything more, nothing more to add.
Yes, Lordship.
Okay, Miss IME. What is your good name?
I am Your Lordship.
I am Chen.
Yes.
Yes, Miss IME.
Yes, Your Lordship, in my affidavit in paragraph 7, I have stated that the grounds of detention have been formulated in line with established facts and circumstances of the case, and the schedule attached to the grounds of detention substantiates the grounds of detention, Your Lordship.
Where is that?
Paragraph 7 of my affidavit.
There are two affidavits. Which one are you relying upon? Affidavit by the commissioner.
Yes, Your Lordship.
Paragraph number
7, Your Lordship.
7.
Therefore, Your Lordship, questioning the legality of the detention order is baseless since the detainee has been detained under NSA as per the merits of the case and all relevant provisions of the acts and the law has been complied with while passing the detention order. Further, it is to be noted that the detainee was arrested for carrying out kidnapping, abduction for ransom for the NSA and IM outfit, which are gross violations of the ceasefire ground rules. Moreover, being a member of such an armed force, such criminal activities are a threat to the public security, adversely affecting the economic development of the state and detrimental to the tranquility and maintenance of law and order in the state. Moreover, such act has caused fear and insecurity in the minds of the people. Now coming to paragraph 9 also, Your Lordship. Here, the confirmation order dated 14/4/26 was issued against the detainee based on the report of the advisory board dated 9/3/26, wherein the board observed that there is sufficient cause for the preventive detention of the detainee.
Okay, before that, where's that confirmation order? It starts with the detention by the commissioner, correct? And thereafter, it goes to the government. Chief Secretary has passed the order. Please tell us the stages. Page 26 is the detention by the commissioner. Where is the approval of the government? By the CS? Signed by the CS?
Page 21, Your Lord. 21.
Oh, 21.
Yes.
You have put it before the commissioner.
The third paragraph, Your Lordship. Third paragraph. Whereas the state of government of Nagaland is satisfied with the view taken by the Commissioner of Police, Dimapur, Nagaland, to prevent so and so from acting in any manner prejudicial to the security of the state of Nagaland and maintenance of public order, it has approved the detention order of the Commissioner of Police, Dimapur, Nagaland, to detain so and so.
This should have come after the commissioner's order. You have put the government's order first
Yes, Your Lordship.
in seriatim. Now, first is the commissioner, then the government has approval, then the advisory board was asked to render advice. And where is the report of the advisory board? No, report is there, of course. Confirmation order. Where's the confirmation order? In the writ petition. Is it there?
14 page 89, Your Lordship.
Page?
89. That is the extension order.
No, confirmation order.
Page 21 itself, Your Lordship. That is the only document that I have received.
21.
Hmm.
Ms. Ayemi, what do you say? There's a separate confirmation order.
Confirmation orders, page 88, Your Lordship, of the writ petition, annexure P.
88. This is 14 April. Okay, 14 April 2026. Your detention is till 18 July,
Yes, Your Lordship.
which will be reviewed thereafter.
Yes.
Correct?
Yes.
Okay.
And
So this is the things we require. You see, at least the facts has to be clear, and it has to be in a chronological order. First of all, arrest, detention by commissioner, approval by government, then advisory board report or whatever, then the confirmation. So we've got these things now. Now you are reading paragraph 9,
Yes, Your Lordship.
but you must keep one thing in mind. These statements made in the affidavit has to be corresponding to what is said by the documents.
Yes, Your
You
Lordship.
cannot make something, like improve upon the case by making
Your Lordship.
statements. That you have to be very clear. Anything you say here, we'll ask you, where is that in the document? So please tell us what else is there.
Now, Your Lordship, coming to paragraph 11.
Hmm.
It is clearly mentioned in the schedule of the detention order in paragraph 4 that the detaining authority was acknowledged that the detainee is in judicial custody at Central Jail, Dimapur. And further, the detainee has moved for bail on 16/1/2026. Therefore, there was the possibility of the detainee being released on bail. And if at large, the detainee will indulge in similar prejudicial activities, therefore, the detainee was preventively detained under NSA Act by the Commissioner of Police. Further, the rights of the detainee has never been violated in any manner. Your Lordship, when we look at the schedule,
Schedule of
page 29 of the writ petition, Your Lordship, paragraph 3 and 4. The schedule with regard to grounds of arrest, Your Lordship. If I may read, Your Lordship, paragraph 3, that as per the records made available by the sponsoring authority, the subject is an active member of NSA-IM and was arrested for kidnapping and abduction for ransom, which are gross violation of the ceasefire ground rules. Moreover, being a member of such an armed organization, such criminal activities and acts are threat to the public security and detrimental to the tranquility and maintenance of law and order in the state. Now, coming to the third paragraph, Your Lordship, extortion in the name of underground groups is directly responsible for abnormal price rise of commodities and essential commodities are the worst affected, thereby causing discontentment among the general public. The victim is a businessman having his shop in New Market, Dimapur. This incident has aggravated the fear and threat of extortion among the entire public community. Therefore, the subject has not only acted in a manner prejudicial to the maintenance of supplies and service essential to the community, but also acted in a manner prejudicial to the maintenance of public order. That the subject is presently under judicial custody at Central Jail and has moved for bail on 16/1/26. If he is not detained, he is likely to indulge in similar prejudicial activities unless effective alternative measures have been called for. On examinations of the records, a report forwarded to the sponsoring authorities, the subject is found to be fit to be booked under NSA. Hence, in order to prevent him from further indulging in such activities prejudicial to the security of the state of Nagaland and maintenance of public order, the undersigned has ordered the detention of the subject under the said act, Your Lordship. Moreover, Your Lordship, all records were placed before the advisory board, and going through the records, they have come to the conclusion that there is sufficient cause for preventive detention, Your Lordship, in connection with regard to the detainee, Your Lordship. And this they have also stated in their report, Your Lordship.
Yes.
That's all, Your Lordship.
Yes, CGC.
My lord,
You did not bother to check your affidavit. It's lying there.
Your affidavit is rejected.
yes, my lord.
Notary stamp is missing. Phone number paragraph is missing. Sign of identification advocate is not there. So these are the defects. Were you informed or not?
My lord, I'm not aware of that.
You were not informed.
Yes.
Should have been informed, isn't it? Do you keep your phone numbers?
My lord,
The affidavit.
my phone number is in the registry. Yes.
It's in the registry, okay, but it should also be in your affidavit. It says phone number is missing, paragraph is missing. Had you put your phone number immediately, whoever's checking it, they could have called you up. Since it's not there, then the person has to go and search for the phone number and call you. So anyway, what is your stand?
My lord, after submitting the representation of the detainee, that one is on 16, but the physical copy is received on the representative detainee was
Yes.
received on 16, but physical copy is received on 24 of March 2026. Lord. Then thereafter, on 25/3 of 2026, the sections have taken an initiative, and that representatives have go here to here and different sections, my lord, so that it is then delay about 15 days. And then thereafter, after considering all the facts and circumstances and report submitted by the detainee authority, where the representative of detainee has no better cause and ground for its consider that representative taking, so that that representation has been rejected.
So what will be? What you do? You get the other two matters. You have same on the same count. What of the see
Your Lordship, with regard to the implication of a pending bail application, I have a judgment which was passed by this honorable court.
Any more apart from that?
No, Your Lordship.
Later on, don't come up again
Paragraph
with some
13.
other judgment like that. I
Paragraph
asked you
13.
also that whether any authority, you are not saying anything.
I was under the assumption that the query was with providing the proper grounds of arrest, Your Lordship. This is with regard to
On any ground, you can submit your citation.
paragraph 13, Your Lordship.
Paragraph 13,
Yes, Your Lordship.
which is regarding.
The implication of a pending bail application, Your Lordship. If I may be allowed to read, Your Lordship.
Yes, read.
This court further finds it relevant to take note of another judgment of the Supreme Court in the case of Amrit Lal versus Union of India, wherein a similar issue arose as the detaining authority recorded its satisfaction for detention under the Act of 1980 in view of the fact that the person who was already in jail was going to move a bail application. This judgment is very pertinent for the purpose of the instant case, taking into account the fact that the uncle of the petitioner's husband had filed a bail application seeking bail on 27/7/2023, which is presently pending. The Supreme Court observed in the case of Amrit Lal Supra that although in the grounds of detention, it has been mentioned that there was a likelihood of detainee moving an application for bail, for which the detention was necessary, there must be cogent materials before the authority passing the detaining order that there was likelihood of his release on bail. In this particular case, the grounds that he was likely to be released on bail, but that was also part of the grounds of detention. But even if that's the grounds of detention, it also has to be satisfied that there are cogent reasons.
Okay, see, in Amrit Lal's case, detention was under what provision?
Cheat entities, I suppose, Your Lordship.
Amrit Lal's case, detention was under what provision? You should have referred to that instead. It's reported 2001. Please take note. 2001. 1 SCC 341. Find out this and take a printout, okay? 2 copies. Give us in the file. Okay, that's all.
Much obliged.
What, Mr.
I am Chen, Your Lordship.
I am Chen, learned counsel for the petitioner, and Ms. A. I.M.E., learned government advocate for the state respondents. Learned counsels have made their respective submissions. Okay, Mr.
Z.N. Muli Malo.
Also heard Mr. Z.N. Muli, learned CGC, appearing for the respondent number 1. Learned counsels have made their submissions, orders to be passed separately. We'll pass the orders in chamber.
Yes, Your Lordship. The other 2 matters, they're same, Your Lordship.
So don't say that. You have to address us. If this is rejected, you mean to say everything will be rejected?
Over the same offense, Your Lordship. I have same ground, Your Lordship.
It's up to you. If you don't want to submit, we will not force you to.
Arrested on the same day.
Yes, Your Lordship.
Okay. Say, no? Normally used to rise at 12. Nobody is not. That's right.
Much obliged.
Orders, item number 21. Then we discuss in the chamber. Yeah, three cases. Huh? It's okay. Nothing much in there.
My blessed Lordship. Lordship, IA is filed for praying for continuation of delay of 830 days, Lordship. On the last occasion, notice was issued to the respondent through the office of the PP of this honorable court, Your Lordship.
What is the status? Who's the PP? No PP.
Who appeared? Keep up.
Bobom is absent today. Miss Ayemi. Miss Ayemi,
Yes, Your
before that, in those three cases, you appear as what? GA,
Yes, Your Lordship.
not as PP or something, GA.
G-
Now, in this case, I think it's a POCSO matter.
Lordship.
So informant has been issued notice to the jurisdictional police station officer in charge. So you are to tell us whether notice has been effected to the informant or not. That is the requirement. What is your instruction? Mr. Thibafom appeared last time.
Your Lordship, he'll be around here, so.
Okay, then we'll pass it over for the time being.
Yes, Your Lordship.
You just tell him that is the requirement. Whether notice has been served or not.
For orders, item number 32. For orders, item number 24.
What to do with 24? Oh, adjourn, correct. 24.
Lordship, this is also same like item 121, Lordship.
Status, yeah.
Yes.
Also, Miss Ayemi. Item 24 also same thing.
Here also keep up. Lordship, I'm appearing for state in this case, Your Lordship. Pursuant to the court's order, I've taken step upon the complainant and we have received the acknowledgement receipt. If I may be able to place the acknowledgement. Lordships, the complainant here has acted in discharge of his official duty, so I'll be representing him.
Who's respondent number 2?
Respondent number 2.
Is
Your
the
Lordship.
complainant.
Yes.
What was
The
he? What was he? What was he? You said that he discharged official duty.
He is an ASI,
And the
police official. Yes, it's a Somoto complaint.
Okay.
Yes.
So what about the appeal? Now, I
Your
is
Lord-
for.
He is yet to dispose. It's for condonation. Yes,
Yes, Lordship.
So we condone the delay.
Lordship, and I reserved the right for arguments of merit here.
On the,
Yes, on the merit of the case.
please write at the outset, Miss
Esmere,
S. Mere, learned counsel,
PP.
learned public prosecutor
Yes.
submits that the respondent number 2 who is the complainant by virtue of being by virtue of his office. Respondent number 2 has received the notice, and that the respondent number 2, in fact, is the officer in charge. Is the
He's ASI.
He's the
Officer on duty.
He's
When
the-
he received the information, yes.
he was the officer on duty when he received the information. Now, in view of above, notice upon respondent number 2 is accepted to be complete. Next para. Heard, Mr.
Nokla M. Kunyak.
Nokla M. Konyak, learned counsel for the applicant, who submits that by filing this application, the applicant seeks combination of
271 days.
271 days delays in filing the connected appeal. Of referring to the application, the learned counsel submits that the delay is on account of bona fide reasons And there was no intention on the part of the applicant to, and there was no negligence. There was no negligence or latches on the part of the applicant in filing the appeal. Most of the learned counsel submits that under the circumstance, the delay of 220, how much? 271 days may be condoned. This as Mayor, learned public prosecutor, fairly submits that. She has no objection in the condonation of delay, and that the matter may be heard on merits. Upon hearing the learned counsels for the parties and on perusal of the statements made in the application, we are inclined to condone the delay of 271 days in filing the connected appeal. So accordingly, the same stands condoned as disposed of. Was allowed. The appeal is registered already. What to do with the appeal?
Let the appeal be admitted and then, yes, paper book.
In view of the delay being condoned by order dated 24/6/2026 in IAC number 17 of 2026, the appeal is taken up for consideration. So part Mr. So-and-so, learned counsel for the appellant, who submits that by filing this appeal under section 446 of the BNSS, the appellant seeks the setting aside of the judgment and order, as well as the order of conviction, both dated 22/4/2025, passed by the learned special judge, POCSO Act, Peck, in GR number 60 of 2023, by which the appellant was convicted under section 376(1), read with section 4 of the POCSO Act, and sentenced to undergo rigorous imprisonment for 20 years and to pay fine of ₹5,000 with the default clause. The appellant was also convicted, and the appellant on being convicted under section 8 of the POCSO Act. Okay, this is separate. The appellant was also convicted under section 8 of the POCSO Act and sentenced to undergo 3 years rigorous imprisonment and to pay fine of ₹500 with the default clause. This is page 1 and 2 of the post title. Next, in view of above, let the appeal be admitted, call for the TCR, issue notice to this respondents. Ms. S. Meyer, learned public prosecutor, accepts notice on behalf of the respondent number 1. The petitioner appellant to take steps for service of notice upon the respondent number 2, as per the prescribed procedure through the registry of this court. What will you transmit as soft copy? What is done normally? You are given you give a soft copy.
Hard copy, yes.
Okay. The appellant shall submit the copy of the memo of appeal for the registry of this court, and the registry in turn shall furnish the same with the notice format to be served from the complainant. Oh, this informant is the police.
Yes, yes. So I'll be representing. So there is no requirement of. Yes.
Then you cancel that. Ms. Esmere, learned PP accepts notice on behalf of both the respondents.
Yes.
And therefore no formal notice is required upon the respondents. The appellant shall, however, furnish requisite copies of the memo of appeal to the learned public prosecutor within 2 working days. Place the matter again immediately on receipt of the TCR.
Obliged.
Orders, item number 21.
21. Yes.
Here also, in person, reports already have taken state, however, we are yet to receive the report. Service report.
Okay. How much time do you require?
Application.
Okay, Ms. S. Merrill, Learned Public Prosecutor, submits that she is yet to receive the report of notice being served to respondent number 2 and therefore prays for some time. In view of above, list again on 15th of July 2026.
For orders, item number 28.
Served. This is a POCSO matter.
Yes, okay.
Is right, Mr. E. Thivapom, Learned Public Prosecutor, submits that respondent number 2 has been served notice. In support of his submission, the Learned Public Prosecutor has produced a copy of the communication dated 4/6/2026 of the officer in charge, Women Police Station, Hek, Nagaland, addressed to the Additional Advocate General of this court. Upon perusal of the same, notice upon the respondent number 2 is accepted to be complete. Anyone appearing? No one appearing?
No one.
We have to appoint. That's. Okay, since no one appears for respondent number 2, we deem it appropriate to appoint Ms. Esther.
Mr. is around.
Esther King, Learned Counsel, as the legal aid counsel, I am asking,
Legal aid.
as the legal aid counsel to represent respondent number 2. What about the TCR? Oh.
Oh, there's a delay.
Oh.
But why did you make the victim a party?
I was not aware of that.
You should strike it off.
Yes, sir. Professional one has been already fine. Yes, Mr. Struggle.
How much is the delay?
1,300.
Okay, any objection
No.
on delay?
No.
Okay, heard Mr. Tushi Longkumar,
Yes.
Learned Counsel for the Learned Legal Aid Counsel for the applicant who submits that by filing this application, the applicant prays for condonation of 1,339 days delay in filing the connected appeal. The Learned Counsel submits that it was due to bona fide reasons, as stated in the application, that the appeal could not be filed on time. Stop. He therefore submits that the delay may be condoned. Stop. Mr. E. T. Wapom, Learned Public Prosecutor, appearing for the state, and Ms. Esther Longkumar, Ms. Esther King, Learned Legal Aid Counsel for respondent number 2, submit that they have no objection to the condonation of delay application, and that the appeal may be heard on merits upon considering the submissions made by the Learned Counsels for the parties and a perusal of the statements made in the application. The delay of 1,339 days in filing the connected appeal stands condoned. I is disposed of as allowed. Then in the main, in view of the delay being condoned, right, order dated 24/6/2026 in IA criminal number 21 of 2026, the appeal is taken up for consideration. Mr. So-and-so, Learned Legal Aid Counsel for the appellant who submits that by being aggrieved with the judgment and order and the order of sentence dated 16/6/2022 passed by the Principal District and Session Judge cum Special Judge POCSO Act Hek in sessions bracket special case number 04 of 2021 corresponding to GR number 37 of 2021, convicting the appellant under section 354 and 376 bracket 2 bracket small f IPC read with section 6, 10 and 12 of the POCSO Act. The appellant has filed the instant appeal. The Learned Legal Aid Counsel submits that the appellant is also aggrieved with the sentence imposed upon the appellant, which is to undergo concurrent rigorous imprisonment for a term of 20 years and to pay fine of ₹5,000 with a default clause. In view of above, let the appeal be admitted. Call for the TCR. Issue notice to the respondents. Since Mr. Idhiba Pom, learned PP, appears for the state and will be representing respondent number 1, and Ms. Esther King, learned legal aid counsel, appears for the respondent number 2. No formal notice is required. And that notice is complete upon the respondents. Appellant shall, however, furnish a copy of the memo of appeal to the learned counsels appearing for the respondents within 2 working days, if not already done. Have you received a copy, Mr. Form?
Yes, sir.
Okay. Then list the matter immediately on receipt of the TCR.
Orders, item number 29.
Yes.
IA, and a file an IA for condemnation of 569 days.
Who's respondent number 5?
Respondent number 5, we have served 2 registered alia on 14/5.
He's a private person, is it?
Private person, Lordship, who was appointed in a then honored post.
Zone Boto.
Yes, Lordship.
So notice is not yet served to him.
However, in this case, Lordship, on humanity ground, I'm not challenging her regularization appointment order. I just am praying before the Honorable Court for providing me future available vacancy in the near future.
Ms. Zimami, we are concerned with the notice at this stage. What is to be done?
Publication in the newspaper or?
No, let us wait for some time. It was sent only in the month of May, 18 May. We'll post it immediately on reopening and we'll ask for tracking of postal consignment to confirm whether he or she has received or not. Okay. Please write office note dated 17/6/2026 indicates that notice was sent to respondent number 5 on 18/5/2026, but return service report is awaited. In view of above, list again on 15th of July 2026 to await service report from the respondent number 5. Office shall also track the postal consignment of the notice sent to respondent number 5 and put up a note by the next date.
Lordship, we need to receive the extra copies of the alia also. I've not yet been sent.
Ms. Z. Zimami, learned counsel for the applicant, shall show requisite copies of the IA to Ms. A.I.M.E., learned government advocate, within 3 working days. Please serve the copy. Yes.
Orders, item number 30.
This postal tracking, it can be done only within 3 months. So that's why whenever you come across it, if you find that it is within the 3 months, you can direct. After 3 months, no problem. The report gets erased. If you've not done it, again fresh steps on publication. Yes.
On behalf of additional AG,
Ah.
I'm asking time to file an additional for lordship. In the last occasion, the IA for confirmation of delay was not accepted. So for that, we can get a file an additional to substitute that record.
By which order? Is it reflected?
There's no.
27.
Yes.
7.5. Okay.
Okay, okay. That was in May. You'll file in only in July then. Oh, what?
Says the additional delay was not forthcoming and we were even able to file our objection.
Okay.
So we have.
You file your.
Okay. On the prayer of Mr. M. Namkumar, learned counsel, learned government advocate, appearing on behalf of Mr. Imti Song, learned additional AG for the applicant. Further, 3 weeks' time is granted to file additional affidavit to support the explanation made in the delay condonation application. List again after the summer vacation.
Also the pursuit the next day if the
It is also made clear that if the additional affidavit is not filed by the next date, the court may consider proceeding with the matter on the basis of materials available on record.
From the supplementary cost list for orders, item number 43.
Forty-three. Straight appeal.
No. Explain the condition of delay.
Same thing, you have not filed.
We have filed yesterday.
Oh, you filed yesterday? But it's not yet connected to the record, I think. This is only amended memo. So we posted on the after the vacation, Mr. Interim also. Mr. V. Zimomi, learned government advocate, appearing for the applicants, submits that he has filed the additional affidavit to further substantiate the grounds for delay in filing the connected writ appeal on 23/6/2026. Stop. Mr. Imti Song, learned counsel appearing for the rest. Mr. Longchan, you are I Longchan.
Yes. Yes.
I Imti Longchan, learned counsel appearing for the respondent, submits that he has received a copy of the same. Stop. However, the copy of the additional affidavit is not found in the record, and therefore registry shall verify and connect the same to the record by the next day. List again after the summer vacation.
For orders, item number 44.
Here also notice.
Who's respondent number 2?
We are the civil organization of the same.
Complainant.
Complainant, yes, Lordship.
So
Chairman of the organization.
notice is issued by the court, and on your part, you have to take steps.
Lordship, yes, we have given extra copy. It was also issued through the.
Through the PC.
Is it so?
Lordship, yes, from PDs or PDs.
Oh, okay.
You're appearing?
You have to ascertain the notice on respondent two.
See, the problem is that there's no indication anywhere in these documents or in the file that copy was given to PP. Only court order is there. Whether the court order has been complied with or not is not there. And Mr. Zimom is not aware, or Miss Mary is aware about this. But are you aware about this? Receiving a copy or not? Okay. As per the last court's order, notice on respondent number 2 was to be routed through the office of the public prosecutor. Stop Miss S. Mary, learned public prosecutor, submits that she may be given some time to check up the status of the notice. List again after the summer vacation.
For orders, item numbers 46 and 47.
Who's respondent number 2? Complainant. Mr. Pom?
Because in the last order, court has started to text through AV office. But I've been informed that he has taken through registry.
No, it will be done through the registry. They will give it to your office.
Obviously, that's not.
He'll come to you from the registry. Don't worry. You have not received. Mr. E. Thimapom, learned government advocate, or learned PP, submits that he has not received a copy of the notice to be served upon the respondent number 2 from the registry. Learned counsel for the applicant, Mr. Metovero, submits that he has already submitted
Yes, on 27.
the notice,
Yes.
the copy of the application
Yes, no.
to be served to the respondent number 2 to the registry on
27, I think.
27/5/2026. No. There is a remark already here. Service of notice issued upon respondent through PP on 2025. Please show this to Mr. Timamo, the first page. Either you or your colleagues might have received it.
They have received T5.
So you take some time and find out. The registry's notice there, they have issued already.
I will receive it.
It may be somebody else who has received it. So just check up with your friends.
I'll take it up.
Please cancel the order. Office note dated 17/6/2026 indicates that notice has been issued to the respondent number 2 through the office of the PP on 3/6/2026. And return service report is awaited. Stop. However, Mr. E. Thivapom, learned public prosecutor, appearing for the state, submits that he is not aware about receiving any notice in the matter. Stop. He however submits that he may be given some time to look into the matter and inform the status to the court. In view of above, list again on 15/7.
For orders, item number 48.
I think you know this. Basic study is file also for convincing below 1 days or so.
First time.
Yes.
Notice will have to go. Correct.
Yes.
Part Mr.
No.
Noklayam Konyak, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 521 days delay in filing the connected appeal. Against the judgment dated 14/11/2024 passed by the Court of Special Judge, POCSO, Fast Track Court, Dimapur, Nagaland, in GR 617 of 2022, corresponding to Special Court Case number 15 of 2022, by which the applicant was convicted under what? 376, capital AB, IPC, read with section 4 of the POCSO Act. 4 and 6 of the POCSO Act. And sentenced to imprisonment
20 years.
for 20 years
10,000 fine.
with fine of rupees 10,000 and a default clause. Issue notice returnable by 3 weeks. Make it 4 weeks. Miss S. Mere, learned public prosecutor, accepts notice on behalf of the respondent number 1. Notice be served to respondent number 2 through the mandatory procedure. Stop. Applicant shall submit the requisites before the registry, whereafter registry shall furnish the learned public prosecutor the notice to be served upon the respondent number 2. Through the jurisdictional police station. List again after 4 weeks. Learned public prosecutor shall inform the court about the status of the notice on respondent number 2. By then.
I don't know if before, right? It's so up to the rules. How do they?
34. You're there for the other side.
Yes,
Mr. Yangavati, learned CGC, submits that as he has some personal difficulties to conduct the matter today, he prays that the matter be adjourned and be listed again after the summer vacation. The said prayers are opposed to by the learned counsel for the opposite party. We hear for list again after the summer vacation on a date to be fixed by the registry. Will assemble at 2, okay?
Yes, Your Lordships. Your Lordships, the hearing item number 32 is not likely to reach today. So my learned friend and I, since there are some other matters also which are likely to be taken up for hearing, would like to make a joint request before the zoning court to release the matter after 4 weeks.
32.
Yes, my lords.
302 IPC.
My lords.
On the joint prayer of Mr. Joshua Singhi and Miss V. Shokre. PP. Attestants adjourned. To be listed again after the summer vacation or a date to be fixed by the registry.
Obliged, Your Lordships.
Your Lordship, Lordship, I beg to mention item number 1. Lordship, I'm appearing on behalf of A. Gauhati, counsel for respondent number 5. Lordship, I filed affidavit in reply this morning, but due to some mistake, it was rejected. So I'll be filing the affidavit in reply in the course of day. So if the Lordship may kind enough to fix the matter on 15 July.
Item 1.
Yes, Lordship.
You are for the petitioner.
Respondent number 5.
5. Your affidavit was rejected.
Yes.
What happened?
Lordship, it's supposed to be, we're supposed to bind the affidavit, but I just step on the trees.
Oh, stapling and binding. That much. I thought there was some major defect. But this is regarding that healthcare thing, no?
Yes.
The other day, all of us were talking so much about this. What is happening? Bills are pending. Respondent number 5 has to respond.
Insurance, no?
Insurance companies keeping the bills pending. So I think there was some observation of this court also in this regard.
Yes, we did pay. We have given.
That's why.
That as to pending case. So now we certain program next. We still we get a pay by the insurance company to the hospitals. So based on that, that we have something to court. They were asked to file an affidavit. In fact, we have received the affidavit, but since it's been rejected.
But what Your Lordships, we have gone through their affidavit, and it says that they have already cleared and they have paid more than what is due.
Okay.
But according to us, Your Lordships, I'm representing the Association of Respondent number 6, Doctors Association. According to us, my clients, they are yet to receive 4 crores something. But according to the respondent number 5, their affidavit, which my notes have not said. They have cleared and.
You have seen it, get it further instructions, and also he also filed a response to the affidavit.
Because our stand was on the basis of the data and evident in the model. But for them, it's just a statement without the sovereign documents. Anybody can make a statement for God. But ours is on the basis of the data.
We'll see. Anyway, let the affidavit be on record, then if so required, we'll call for them to bring with the records, come with the records and produce this thing to the court. So when do we have it?
On 15.
15? Yes, what's your good name? Miss A. Konyak, learned counsel for the petitioner, submits that although the respondent number 5.
Respondent number 5.
Sorry, learned counsel for the respondent number 5 submits that although an affidavit was filed this morning in terms of the direction of this court, but the same was rejected by the registry on account of certain what?
Defects.
On account of certain technical, on account of certain defect. To stop, she submits that she may be given some time to rectify the defect. And therefore, matter may be adjourned for today. Mr. Joshua Sheki, learned counsel for respondent number 6, and Mr. N. Mozui, learned counsel for respondent number 4, submit that they have received an advance copy of the said affidavit of respondent number 5, and they may be given liberty to respond to the same. Now, in view of above, matter stands adjourned to be listed again on 15th of July 2026. Respondent number 5 shall rectify the defect and file the affidavit without further delay. The counsel for the respondents, the other respondents would be at liberty to respond to the affidavit of respondent number 5 in the meantime, if so advised. We'll record the name of Miss Kiki also. Miss K. Kiki, learned counsel, appears for the petitioner.
Lordship, I'm grateful, Lordship. May I please, my lord?
Yes.
Lordship, may kindly allow me to make a mention for item number 3 to 10, Lordship.
Why you don't mention the morning?
Lordship, in fact, we have given an adjournment slip also.
That is
yesterday.
why you
Yes.
should have mentioned in the morning that I have circulated adjournment slip.
Yes, you're right. I thought the admission items will be taken up first, so since it is listed only on item 3.
We could have
Lordship,
done
I
that.
got hesitant
Okay.
to, yes.
When do you want?
Lordship, after 4 weeks, my lord.
No objection from the other side? Mr. Enangami, learned government advocate appearing for the state. Respondents submits that. What is the ground for adjournment?
Your Lordship, the appellant herein has filed one additional affidavit, and I am yet to receive instruction with regards to that additional affidavit, my lord.
Submits that he is yet to receive instructions on the additional affidavit filed by the appellant. And therefore,
No, Your Lordship, I am yet to receive. I haven't received, my lord.
he is yet to receive.
My lord.
You can hear me, no? Is yet to receive. Is yet to receive instructions on the additional affidavit filed by the appellants, and therefore prays that the matter be listed again after 3 weeks. So he also submits that he has circulated an adjournment slip. Ms. Luceno, learned counsel appearing for the appellants. And Mr. I. Imchen also appearing in item number 4, in
Read appeal
Writ Appeal 30 of 2025. I have no objection to the prayer. Next para in view of above. List these matters again after the summer vacation on a date to be fixed by the registry.
My lord, place an interim in.
Interim
Appeal
order.
30.
Passed earlier, if any, may continue till the next date of listing.
I am deeply obliged, my lord.
For orders, item number 50.
15,
Right, please, your lord. Am I audible, my lord?
50 or 15? 50, okay.
Am I audible to your lordship?
Mr. Aji, yes.
I am on the RVC, my lord.
Oh, I'm sorry, you are Mr.
Thank you.
Yeah. Yes.
But there's some delay of about 120 days in filing the writ appeal.
Notice.
I have 134 has been filed. I have
Notice.
explained the delay. In fact, my lord, the Honorable Single Judge has heard the matter and concluded, my lord, at the Kohima bench. And the judgment was pronounced in the month of, my lord, January 2026 at the principal bench. So counsel and the applicant, they were not aware of it. my lord.
Will issue notice at this stage?
Lodge.
But Mr. Vijay Sekia, learned counsel for the learned senior counsel appearing for the applicant, who submits that by filing this application, the applicants seek condonation of 120 days in filing the connected writ appeal.
28 of 2026.
Against the judgment and order dated 21/2026, passed by the learned single judge in WPC number 94 of 22, correct?
Lodge.
Issue notice, returnable by 4 weeks. Anyone appearing? State?
State ought to have been appearing, but I don't see, my lord.
Mr. M. Naukumar, learned government advocate, accepts notice on behalf of respondent numbers
2, 3, and 4.
2, 3, 4.
Lordship.
2, 3, and 4.
May I pray for a date, my lord, in the month of August, my lord. If not.
As such, no
inconvenient,
copy
but-
notice is required. Extra copies be furnished to Mr. Naukumar within 2 working days by the applicant. applicant to take steps for service of notice upon the respondent number 1 by speed post within 3 working days. List the matter again on, you want a date?
Lordship, my lord. If not inconvenient, my lord, 12th of August, my lord.
List the matter on, again on 12th of August, 2026 as paid for. The respondents will be at liberty to file their objection to the alia in the meantime, if so advised.
Not considering the, my lord, the direction contained in the judgment, my lord, by the judgment, my lord, I am directed to, my lord, comply with the direction therein within a period of, my lord, time frame, my lord. And
So,
this time has already expired, my lord. So therefore, my lord, may I appear for a status quo with regard to the, my lord, judgment, my lord.
can we pass status quo without condoning the delay? I don't think
This
so.
another, so this is of course a writ petition, my lord.
If you want a short date, we'll give you a short date.
But again, my lord, notice will have to go, my lord.
So you return of a date.
Lordship.
Bless you, Lordship.
Obliged.
For orders, item number 51.
Please, your lordships, this IA is for condonation of delay of 110 days.
110 days.
Yes, your lordship.
First time, isn't it?
Yes.
Let notice go. Your good name?
Imnirinla.
Heard Miss
Imnirinla.
Rinla.
Yes, your lordship.
You have to give in writing. Learned counsel for the applicant who submits that by filing this application, the applicants seek condonation of 110 days in filing the connected writ appeal against the judgment and order dated against the common judgment and order dated 12/12/2025, passed in WPC number 58 of 2024 and WPC number 59 of 2024. Stop. You are the petitioner.
Yes, your lordship.
In which writ petition?
In
58 or 59?
58 and 59, both.
You are there in both.
Yes.
Same petitioner or what?
No, your lordship.
Different.
Yes.
And appeal is filed, one appeal is filed.
Yes, your lordship.
They have filed an appeal in both. Actually, they should file separately, but they have.
Yes, that's what.
Yes.
Or
You'll
even otherwise, also they don't have a case. They are in illegal occupation of government land. The judge's bungalow in Kohima.
This is the.
Yes, judge's bungalow. Yes.
I see.
But there are two writ petitions.
Yes, they should file separate.
And WP 59.
Yes, lordship.
Next para, issue notice is returnable by 4 weeks. Ms. V. Shukrel and National AG, accept notice on behalf of the state respondents.
1 to 5.
Bracket respondent numbers 1 to 5. Who is the standing counsel? High Court?
Sir Akito Zimomi.
My lord, I was informed that there's a notification now that the notice has to go to the registrar first, and then only the registrar will endorse the case to us. That was
Okay.
what I was informed.
Okay, then petitioner, applicants to take steps for service of notice upon respondent number 6 by speed post within 3 working days. Release the matter again after 4 weeks. Respondents may file their objection to the IA if so advised in the meantime. Next para, the applicants may also explore or examine as to whether two separate applications are to be filed. Considering the fact that the impugned judgment and order is rendered in 2 separate writ petitions initiated by 2 different persons. We'll keep that on the record so that we are reminded next time.
For admission, item number 2.
May I please, your lordships?
This matter has come up because on the last occasion, last week, I've made a mention for listing of this matter.
It was supposed to come in July, but suddenly you have come in a very great hurry.
No, Your Lordship, if Your Lordship may kindly peruse the last order,
Oh, what?
18/3/2026.
Oh, this is item 2, isn't it?
Lordship,
Item 2.
Correct.
Lordship,
it is an appeal filed by the union, Lordship. And
It has been listed on the mention made by,
made on my behalf, Lordship.
respondents.
you are for the respondent.
Yes, respondent, writ petitioners.
Okay.
So if Your Lordships may kindly peruse the last order, that is 18/3/2026. Lordship has got it?
Yes. This has been cured.
No, Lordship,
It's been
that I
rejected.
had mentioned.
It has been rejected again.
It's almost 3 months, Lordships.
No, having regard to this order, it says that without pleadings of the learned single judge, before the learned single judge, that means the writ petition, counter affidavit,
Lordship.
and rejoinder, if any.
They have annexed only the impugned judgment without any pleadings.
Now I think they have annexed it.
We have annexed it.
No, Lordship, we have not been served with that copy.
You have not been served, but we find it here, available here.
Yes, Lordship. It
The
was,
only problem now, further problem is that
yes.
it is not legible.
And these are all the documents, Lordship. And these are all the documents. The documents that was supplied to us in the writ
So-
petition. This is it's illegible. That is why the documents could not be.
Lordship, they have got
No.
sufficient time, Lordship.
That part is over. When it was a writ petition, rightly or wrongly, court had entertained the writ petition, despite the annexures not being very legible.
Defect,
So
yes.
some order was passed already, which you have challenged in this writ appeal. And now, can you say that it was the same document which they have annexed? It's not. It's nothing to do with me.
Because it's a.
So I have annexed it.
Yes.
And whether it's legible or not, I don't know what.
Yes, Lordship.
Can you say that? You
Yes.
cannot.
That is what I understand, Lord.
No. That would be a wrong understanding. I think if you go to the apex code, even if you have many documents which are printed, they type out everything again. Everything is typed out again, so that there is no complaint regarding the legibility or otherwise. Things are all properly typed. But here we accept even photocopies which are here printed.
What I wanted to say,
Here-
Lordship,
There are documents which are not legible,
yes.
so we would impress upon you to
Yes.
get it typed.
That's why I coming here today is I need some more time to type it out.
Correct.
So because it's
see,
a few documents.
You have enough resources.
Yes.
Okay.
I got.
You have enough resources. You tell them, type this out and give it to me. Then you can get it
I can type it out, Lordship, because of the type of concern because the orders that come from Gauhati. And
Lordship, because of this appeal, the contempt is also kept pending, Lordship.
So
there is no stay as such, Lordship. The stay is still district today, 170.
by what time can you file? You rectify the.
At least a month's time, Lordship, because there are so many documents.
By default, you'll get 3 weeks because of break.
Yes.
1 more week.
Yeah, because of break.
Lordship, right after the reopening of the.
Lordship, the problem is during the break, my juniors will be also be on break.
No, don't ask them to be on break. Tell them to do the work.
Lordship, they've got sufficient time. It's more than
That
3
is-
months,
that
Lordship.
That
may be considered.
May I pray for 30 days time?
You're not satisfied with 4 weeks. You want 30 days.
That's for.
Lordship, we may fix on 15, Lordship.
It's the same thing. 1 month and 30 days is the same thing.
Maybe 22nd.
Please write, although the appellants have incorporated the pleadings before the learned single judge, but some of the appended documents appear to be not legible. So in fact, registry has put up a note dated 19/6/2026 in this regard. Stop. Mr. Gauhati, Learned Counsel, Learned CGC, appearing for the appellate, submits that he may be given some time. He may be given a month's time to rectify the defects. Stop. Mr.
I, Jamir,
Learned Counsel, appearing for the
respondents.
Submits that he has not received a copy of the pleadings said to have been incorporated by the appellants, and that the contempt petition filed by the writ petitioners has been kept pending in view of the instant appeal. So he therefore submits that there is urgency in the matter. Next para, in view of above.
Lordship, this may be last opportunity for
As paid for by the Learned CGC, we grant the appellants a month's time to rectify all the defects. List the matter on 22nd July. Enough time?
22nd, Lordship. When, Lordship?
22nd July.
Lordship, if it can be observed on the next day, if they have not cured the defect, then it will be dismissed, Your Lordship.
There's last chance, Lordship. No, please don't make such observation because
they have got sufficient time. That may be considered almost, it's been more than 3 months, Lordship.
In fact, it will help you. If you don't have that observation, they will not work. It is made clear that the appellants should not seek further time for making the rectification of the defects. That much will do, I think.
Okay. Obliged, Lordship.
For admission, item number 11. My application, Lordships, as per the last court order, Lordship, the matter was supposed to be listed on 27 July, Lordship.
Yes, this is the
However, we have, we found out that there is some error in the order. There is some error in the court order, which is why.
Which order?
Order dated 25/02/2026, Your
25.
Lordship.
Passed in this writ appeal.
Yes, Lordship. Interim was
I don't
granted.
find such. Just give me the date again.
25/02/2026, Lordship.
Okay.
So in the last line, till the returnable date, the impugned judgment dated 23/09/2025 passed by this court in WPC 140 of 2024 shall remain stay. So it should have been 141, Lordship. WPC 141. 141 of 2024.
I see. So what do we do at this stage? You want us to clarify that?
Lordship, that is my humble prayer, Lordship.
And we list it in terms of the earlier order in July?
Lordship.
Or what?
Yes, Your Lordship.
One more thing is some dusty affidavit is filed.
Yes, Lordship, yes. We were also asked to take steps through dusty service, which we have already done, and a compliance affidavit also already been filed, Lordship.
To the respondent number 4.
Yes, Lordship.
What is your good name?
Nagaland Konyak, Lordship.
All right, Mr. N. Konyak, Learned Counsel for the appellant, who submits that although right order dated 3/6/2026, the matter was directed to be listed again on 29/7/2026. But as there was some typographical error in the order passed on 25/2/2026, he has made a mention for listing the matter today. Stop referring to the order dated 25/2/2026. The Learned Counsel submits that WPC number 140 of 2024, appearing in the said order, in fact should read as WPC number
141 of
141 of 2024. And since the same appears to be a typographical error, both may pass appropriate order. Next para, considering the above submission and on perusal of the records, we find that the same is only a typographical error and WPC number 140 and therefore the order dated, the order of stay passed on 25/2/2026 shall be understood to be a stay order passed in respect of WPC number 141 of 2024. 141, huh? Don't make the mistake. Then next para. This is the Dasti on respondent number 4.
Lordship,
The learned counsel further submits that as permitted by this court, notice has been served upon respondent number 4 by way of Dasti and an affidavit to that effect has been filed. On perusal of the affidavit dated 15/6/2026 filed by the appellant. Notice upon the respondent number 4 is accepted to be complete. List the matter. On 29/7/2026. In terms of this court's order dated 3/6/2026.
Lordship, there is an interim academic extended.
What interim?
Lordship,
Already passed.
It's already passed.
This interim order is not for a particular time. It is still it just, there's no return. Okay. Return of date. Okay. You're right. Then you're right. Till then, the interim order passed on 25/2/2026 and clarified by the instant order shall continue.
Obliged, Lordship.
For hearing item number 31.
May I please, your lordships?
Yes.
Lordship, before my learned friend make his submission, it may not be possible to conclude this case today. So my respectful submission is if the lordship can accommodate us tomorrow also after 2 to conclude this matter.
Tomorrow?
Yes, if it is possible. Otherwise, my lord, to keep the matter parted, whether it would be fair. Because it is now 2:30 and it may not be possible to, in the next 2 hours, to conclude the matter today. We are ready for disposal, but in view of the time constraint, if lordship can kindly accommodate us tomorrow at 2, after 2. If not, lordship to keep the part-heard matter again when the appropriate division, lordship to be constituted, that is the problem.
Time constraint is there.
Lordships.
Ideally, I think preferably we had started last week. At least
Lordship, on the earlier occasions, this matter was to be listed on the top of the list also, because there are several orders. Because instead of considering the interim, the parties have arrived to a consensus that instead of considering the interim, better hear the matter and dispose of once for all. So we have agreed And then we have made request to the Honorable Court that this matter may be listed on the top of the list. In fact, it is listed on the top of the list. Today also it is the first item. There are certain things, in spite of our best effort, the things could not work out also. And this is one of such kind, Lordship. But then on the earlier occasions, when the matter is left part, then normally division bench are being constituted. But there is no hard and fast rule that division bench can be sit only on Wednesday. And I believe there is no High Court rules also. It is just a convention. On the earlier occasions, even last month, on the prayer of the councils, the division bench was constituted. And today we are at 2:45. Now I will take about 1 hour. And I believe my learned friends may also take half an hour or a similar time. So if Lordships can accommodate tomorrow for 1 hour, I believe we can conclude it. As far as possible, I will also try to refer only to the relevant portions instead of referring to the detailed judgment.
See, we are aware about the time constraint. That's why we tried our best to speed up the matter today.
Earlier occasions also it was
cases listed today.
on account of time constraint. The matter was deferred several times.
Another option is perhaps to have the continuity of the bench. Why don't you have it after the vacation immediately?
Since it has reached the item, if Lordships constitute the division bench tomorrow,
you can take up the matter now.
If tomorrow is constituted, DP is constituted, then we can finish it.
No, the problem is that you may finish it, but for us, it will become very difficult. We have received the roster. So we don't know when this bench will be available. That's the thing. So to leave half things half done, half finished will not be fair. And this is not a case which has come up for the first time. It has a checkered history, I believe.
This is the 8th round of litigation.
So your synopsis also runs in 4 pages, I think. Yes. For a history like that, this is the thing. So preferably, if the parties agree to have the continuity of the hearing of the bench, you're right in saying that it is only by convention. Supposing you take the matter for hearing on another date also, you can always request that since matter was part-time, maybe we may continue tomorrow like that. I think that will be most appropriate, considering all the aspects.
In that case, Lordships, I would suggest that let it be immediately after the vacation and let it be in as the first item in the hearing list, and then the court should also accommodate for early disposal.
See, since we don't know who, since it is not going to be the same court,
yes,
it will not be fair on our part also to put some observations saying that.
Last occasion, first item, Your Lord. Last occasion.
Lordships are aware today. At least more than 15 cases are fixed on 15th. So we can take it for granted because 15 is the first reopening day of the division bench. On that day, even today also, more than 15 cases were fixed on that day. So we can take it for granted that even on the first working day, this is not likely to be reached. That is the problem, Lordships.
And the other fixed matters also earlier, which was fixed on 15. So at least on 15, it will.
These are all accommodated because of the fact that the division bench is sitting only on Wednesday. But when the matters are left, then
that will leave it to the parties to your wisdom on that day.
Yes.
If you have the feeling that it may not reach, you can always impress upon the court that we may have this matter briefly today and may continue tomorrow like that. Definitely, the court will consider this aspect.
Request can be made to the senior judge to constitute the division bench even on Tuesday, Monday or Tuesday, anything.
Lordships, that we can exercise.
Or if Lordship is gracious, will be given an observation to give us the liberty to request.
To list the matter immediately after the vacation.
Mr. Takamasali, but he's always there. But if that indication is given, it may send wrong signals.
It's all right, it's all right, Lordship.
That's why.
No,
In view of the urgency involved, the matter may be listed immediately after the vacation, so that we can also avail other options to make a mention before the honorable
Please write. Although,
judge.
although on the prayer made by the learned counsels appearing for the rival parties, the matter was listed as the first item in the hearing column, but paucity of time does not permit the matter to be taken up today. And therefore, as agreed to by the parties, the registry shall list the matter as the first item in the hearing column on 15th of July 2026. Will do. The rest, I think,
이것들 코스트 소모지님이 디스포스로서